The Supreme Court has, by a majority decision 3-2, dismissed Vincent Eko Assefua's interlocutory injunction seeking to have the suspension warrant issued by the president to have the Chief Justice suspended pending the determination of petitions seeking her removal. This was after his lawyers, led by Godfred Yeboah-Dame, the former Attorney General, advanced his argument and same opposed to by the Deputy Attorney General, Dr. Gertrude Torkornoo. But moments after all the parties have made their case to the court, the panel retired, and by the decision of the court presided over by Justice Paul Bafuboni, their decision was that 3-2, with Justice Professor Henry Samensa Bonsu and Justice Ernest Gawu dissenting. The rest of the three, including the Chief Justice Paul Bafuboni and Justice Omoro Tanku and Justice Emmanuel Yoni Kolendi, the decision is that the application has no merit and same has been dismissed. The Deputy Attorney General, Dr. Gertrude Torkornoo, makes the point that nothing stops the president from continuing with the processes to have the Chief Justice petition looked into.
The process will go on. The committee would sit, they would hear the inquiry into the matter. And of course, I have always maintained that the finding of prima facie case is not automatic that the Chief Justice or the person who is being, who is the subject matter of the petition has been removed. It is not at all. So it may come out that the Chief Justice, the petition has not been of merit, and the Chief Justice will be restored to her position. I am always surprised that people have concluded that the fact that prima facie case is found, then it means that the Chief Justice automatically is removed from office. And you could see that is what actually motivates this petition, this motion that have been filed. I think the underlying understanding, which I consider a misunderstanding, is that the plaintiff believes that when a prima facie case is established, then it's a gone issue. But it is not.
Godfred Yeboah-Dame, who earlier raised objection to the inclusion or to off Justice Paul Bafuboni presiding over the case, expressed his opinion on why he raised the objections.
The reasons for the decision have not been known. Of course, clearly, the spirit of Article 146 we're talking about. In the first place, it is important to indicate that nowhere in Article 146 will you find a requirement for prima facie intervention made for a Chief Justice. But the Supreme Court itself imported that into Article 146 in 2005 when it authenticated on that issue matter. But of course, the Supreme Court was silent on whether there ought to be notification to the Chief Justice and obtaining of his comment before triggering the process. And that is what is in this week before the courts.
The applicant in the matter, Vincent Eko Assefuah, has also been reacting. Is it the end of the road for him?
I don't think it's the end of the road, but let's just get the reasoning first. When we get the reasoning, of course, the 3-2 ruling suggests that the Supreme Court itself sees some reasoning in the arguments that we make in court. It tells you that our argument or the reasoning that we advanced in court was quite potent. And so let's get the reasoning, and when we're able to get the reasoning, we'll be able to decide.
Clearly, the parties will want to see the full reasoning of the apex court will be ready by 31st of May. Until then, the parties will have to accept the decision it is now until further notice. From the Supreme Court here in Accra, Murtala Inusah, GHOne.